remarked, there's a nice education system. So I'm speaking now with University of Stellenbosch in South Africa, with the University of Paraná in Brazil, and others. So at the next winter term, we'll have perhaps 10 universities supporting the idea of LDE, which is a marvelous success. So now I'm proud to present Sergi. For me, it's a very silly task because I know Sergi since years. I feel like a close friend of Sergi. He's a professor from Tiflis, TSU. His name sounds familiar to all Georgian because Jorbenadze is a very, very known name in law. His father was a famous lawyer. He is a famous lawyer. So the TSU is the biggest and eldest university in Georgia, in Tiflis. If you are one day in Tiflis, never avoid to go there and see this marvelous building and these remarkable facilities, nice colleagues, amazing students. I will go there in summer and stay there during my sabbatical. So Sergi is especially known for internet law and especially for one feature of internet law or for defamation law. As he is not only working as a professor, but as well for a really known advocate firm in Tbilisi. He is mainly doing defamation law. He's just in the process of publishing a remarkable book on AI and law, first book in Georgia. But defamation law is really his specialty, especially not only taking Georgian law, European law, but as well US and British law. I am very, very honored to listen to him. He will speak for 1 hour, 50 minutes. I will send his recent slides to you after the lecture. Mr. Mendes, Georgians do not only eat chinkali, but other things as well. So it's up to you, Sergi, to start the lecture. Your time.
Thank you very much, dear Thomas. Thank you very much once again. It is a big pleasure for me to be here and make presentation about defamation law in internet cases. So before I start the presentation, I would like to give some background of the presentation, a small history, I would say. Before I prepared this presentation, I had been working more than 4 or 5 months with the European companies. It means the companies which are based in European countries, in Germany, for example, or in France, in Italy, in the UK, and so on. As well as I had communication with the companies which have representations, for example, branches in Germany as well as in other EU member states. And I went to these companies with the question about defamation. So what was the main role of defamation on, or I would say what kind of role defamation played in the practice of these companies? And according to the answers I collected from this company, I had identified the points that are most interesting topics for this presentation and from the practical view. And I would like to show you all these details according not only from the scientific side or theoretical side, but also from the practical side. So let me show you, first of all, the main topics I will be covering today. And wait a minute, you can see, here's my presentation. First of all, I would like to speak about acts and regulations, because this is the most important point, I would say, if we speak about defamation and European regulations and acts. So in the online era, because of online activities, this is really important point to see where defamation, directly or indirectly regulated is. The second point is the key issue or key issues. Because when we speak about defamation, we have to explain, or we have to ask the main question. The main question, what is the defamation and how is this defined, and so on. I will try to find some answers to this question, and I will show you some details about these details. The third point is US approach in practice. And why US? Because I think if we speak about freedom of expression as well as about defamation, we have to explain some points from the United States of America. There is developed some cases or case law, which is important also for the European countries. And I have already seen some details in the local European court decisions where they use some US practice. I don't mean that this is written in footnotes, for example, but US approach in practice in European Union plays a big role. And we can find some similarities as well as some differences between American and European practice, as well as how to solve this problem, for example, according to the American experience. The fourth point is burden of proof, because when we speak about defamation, we have to explain what kind of role the plaintiff or defendant has. And we have to also explain this practical side according to the case law, which are made, or decisions which are made from the international courts and so on. The fifth point is private and public figures. And private is a figure or is a person. For example, the plaintiff, private figure or public figure, plays a big role, a huge role, I would say. And it means that the court can think or decide according to this point, according to the recognition of the person as a private or public figure. As well as I will speak during this presentation, during this point, also about legal persons, because legal persons plays also crucial role in this area. The sixth point is challenges of the internet era, and I would like to show you some details from the case law, from international court practice, and I will show you some details from the European Court of Human Rights practice as well as CJEU. The seventh point is AI and defamation. I would say it is the newest point, not only for European countries, but also for the United States of America, as well as for Australia and so on. And there are some details whereabout we have to speak, I think, or we have to mention, because this is our future, and it is really interesting from my side. And the last point is conclusion. I will try to collect everything whereabout I will be speaking during the presentation, and after conclusion, we will have possibility to discuss about some cases or hear your comments, because as I see, the attenders or participants are not only from one country, for example, for Germany or Georgia and so on, and it will be very interesting to hear how the defamation in your country regulated is. So let me go to the first point, and it is a point where we will speak about acts and regulations. So acts and regulations, I want to show you more than one act and regulation. And why? If you ask the question, my answer is because there is no regulation or act about definition in the European Union which explicitly regulate defamation or defines defamation in this area. First of all, DSA Act, which is really important point and significant role plays, I would say, in this area. When we speak about platforms, when we speak about social media, and so on. Second one is a big brother of DSA Act, because ACD was the first directive in this area, and we have some cases according to this directive also in the international court practice, and we will also explain the details on, we will have possibility to hear these details according to the international court practice. Next one is anti-SLAPP directive, and in this case we have the newest directive and newest regulations about anti-SLAPP activities, which is new not only for the European countries, but as I already mentioned in other cases, this is also the newest point I would say for the United States of America. And when I speak about US, I want to take some cases from the American experience. Next one, it is Brussels I, because when we speak about international defamation and when we speak about some details, how the plaintiff able is or not, the plaintiff able to start lawsuit about defamation in the member state, we have to speak about international private law as well as about recognition and enforcement of the decisions of the international or local domestic courts. Brussels I plays a crucial role in this field. Next one, it is EMFA. It is European Media Freedom Act. It is main regulation, I would say. Of course, does not define defamation and is not defined defamation, sorry, in this act, but it is very important to see whole picture, I would say, and to see what kind of direction defamation or freedom of expression in this area has. Next one is the Charter of Fundamental Rights of the European Union, when we have some rights which are freedom of expression as well as private life and so on. And same position is in case of European Convention on Human Rights, where we will be able to speak about also freedom of expression, and when we will be able to speak about the borders of freedom of expression as well as private life according to the experience which European court practice already made or decided. There is also very important to speak about national regulations. I will not go deeper to these regulations, for example, German legislation or French legislation and so on. But when we speak about acts, about globalization or main directive, we have to explain some details according to the legislation of several countries. And I have taken several countries, for example, Germany, and I will explain some details about that. So, but before I go step by step to all these acts and regulations, I have to show you one very important detail, one crucial detail, whereabout we have to speak about defamation. The European Union, or I would say EU law, does not explicitly regulate defamation. There is no direct EU regulation on defamation in European Union. If we want to speak about defamation, we have to find it in several acts, and according to analysis of several acts, we have to show them what kind of decisions the court can make. And according to this praxis, and according to this reality, I have to go to the first point, and it is DSA Act. And you have already heard during these presentations this project about the DSA Act, but I want to draw your attention to the point, Article 3H, where it's written about illegal content. So DSA does not define defamation as well as I already mentioned, but here is very important point to speak about illegal content and to speak about some details which are really, really important in this case. Defamation is an illegal activity. Because of that, we have to say that defamation falls under this definition. And defamation is one type of illegal activity, and it means that main European instruments for defamation cases are against platforms, are regulated these activities or these roles in DSA. But as an example, I want to show you one case. It's the newest case. It is from 2025. It is from December 2025. And this is case against X. And maybe you know this case, but what is here very important from the side of defamation. This case was not about defamation, and also in decision or all the documents are not written about some defamation activities or defamatory statement and so on. But here is important point to explain that the procedure started with the elements of illegal contact. It means if you see some articles on explanations and so on, you will see that there is written about defamation some point. So according to this activity or according to this case, we can say or we can analyze that defamation is also one type of illegal contact, and in case of defamation, DSA Act can have some influence for the platforms and so on. But DSA Act is not everything, as well as other acts. I would like to show you some details from the praxis, which is already established in Georgia as well as in the United States of America, but does not play a crucial role nowadays for online cases, for online defamation cases. It is social media platform. And what does it mean? I think so. I have a question. Is this or not a step towards the future? It is the gate to the future or not? And what does it mean? Social Media Council can be called as a quasi-court. It is between court hearings or between lawsuit and between plaintiff's position. Social Media Council can solve all the problems, all these activities or difficulties in online cases, in online defamation cases. And what does it mean? According to the experience of the SA, we can have in the future social media council. As I already mentioned, in the United States of America, there is already established social media council, but does not work very active. In Georgia, we have already planned, and not only planned, but established also social media council. And the main idea to do it or to solve the problem of online defamation, and not only the online defamation, problem of illegal contact in social media or online and so, was social media council. What does it mean? If a plaintiff has a position that the statement was defamatory and wants to go to the court, he can do it, of course. In every country it is of course not problem, but he must wait, or he has to wait, I would say, approximately 1 year or 2 years and so on, because length of hearings or this lawsuits and so on does not play a good role in case of online era. And if we speak about the experience or history, for example, in case of traditional media, TV or radio, as well as magazines and so on, in this case was a very different situation, because online media can everybody can have access to online media and read this article or defamatory statement and so on when they want. So because of this reality, I think social media council must play a big role. It is the idea, not from me, it is not my idea, but idea of American scientists. And this idea means that social media council will decide the claim. So the plaintiff can submit the claim to social media council and not to the court. Social media council must make the decision directly, so as soon as possible, in, for example, 10 working days. And this decision must be enforced from the platforms. So this is the main idea of social media councils, to be enforced this decision from social media platforms or online platforms. And we, as I already mentioned, we have already collected the researchers, scientists, as well as journalists, and also some lawyers from the whole world. It was from Asia, as well as from Africa, New Zealand, Australia, of course, from Europe, as well as from the United States of America, from the UK, and from Georgia, of course. And the idea is to have the social media councils, the chambers, and every chamber will be able to make some decision. And as I already mentioned, this decision must be enforced by the platforms. But what is the main problem in this area or in this field? Two main points, I would say. First of all, this is the recognition from the platforms. Do the platforms want or not to do it? It is a question, and we don't have the clear answer, but this is future, of course, for them. And second one, this is, of course, financial support. This is technical, but very important. Because we don't have this financial support, because the government, not only Georgian, but for example, German or British and so on government will not able or will not give some financial support. It is not easy to start this activity. But as a model of quasi-court for social media online cases, online defamation cases, or about illegal content, I think this is future and will be the future of the CAA. And one more point, and then if you have some questions, we can speak about the social media council after the conclusion. After I have already make this presentation and this presentation, social media council can be the base point for the online activities, because in this case the plaintiff, of course, will go and will have in 10 working days the answer or decision, but he will also have possibility to go to court, as well as the defendant. So it does not mean that that this is only borders of freedom of expression, but to solve this problem as soon as possible, we have this idea, and Georgia can be an example country for the whole world. We can see how it in our country works, and if it works very well, then other countries can take it in the legislations. So we can discuss about that if you have a question. And now I have to go to the next point, and this is ECD. As I already mentioned, this is a big brother of DSA, and there are two main points. If we speak about freedom of expression, as well as if we speak about defamation or illegal content and so on. First of all, it is hosting, Article 14, and second one, this is no general obligation to monitor, but what kind of role this directive in the practice or in a court experience play, we can show with the example, this glowishing Piszczek case against Facebook. But here is a very important point, which I have to also explain or show you, that there is no general monitoring obligation from the platforms, but liability is defined through the case law, and because of that, there are some details which are decided by the court, sometimes vice versa. So I will speak about these details, and I will speak about this point, because in case of online platforms, it plays a crucial role, I would say. Next one is Brussels 1. And as I already mentioned, Brussels 1 is also a very significant point or very important act or regulation, because when we speak about cross-border defamation, so-called international defamation, we have to speak about two details. First of all, it is jurisdiction, and second one, it is recognition and enforcement. In both cases, Brussels 1 plays a big role, and you can see the case, or about I will be speaking also during the point about this Swedish case, as well as I will show you another case about recognition and enforcement, which is the Real Madrid case. It's also an ongoing case, but from CJEU, we have already the decision, or CGA EU has already decided, and there is very important explanations from the International Court, Real Madrid against Le Monde. And it is also defamation case in this area. Next one, this is anti-SLAPP directive. And as I already mentioned, there is also not defined defamation. There is not written that defamation is this point and so on, does not have any explanation and so on. But, however, if we speak about Recital 11, highlights the need to protect participations in public life. And we all know this anti-SLAPP activity, what it means, and what kind of role anti-SLAPP activity or anti-SLAPP directive in nowadays has. And it is so target group according to this directive are the journalists as well as media, activists, public watchdogs, whistleblowers, and so on, the people who can play a big role in the society, or who have some influence to the society. But I want to bring only one point from this directive up, and I want to speak about the directive according to the criminal procedure law. Because if we speak or if we see Article 2 of this directive, we can see that this directive shall not apply to criminal matters. And what does it mean? And I would like to explain it with the example, because there are some countries, for example, Germany, where defamation is regulated in criminal code. And if it is one type of criminal law, then we have to speak will or has or not directive some influence for the country or not. So defamation, as I already mentioned, also arises in criminal law. And we can go with the example. For example, in Germany, a plaintiff or potential plaintiff applies police or organ which is able to start some defamation activities against the defendant, and started this application with the explanation that he, for example, published the defamatory statement and so on. But the main ground or main goal of the plaintiff was to do everything unfair against legislation, I would say, against the rights of this person. And it is one good example of anti-SLAPP regulations. And if we speak now that anti-SLAPP regulations cannot be used in case of criminal cases, we can also decide from the formal side that in Germany it cannot play a role, because in Article 187 of Criminal Code of Germany is called Verleumdung. It is written and regulated. But we can speak also about private law cases. But first of all, I would like to show you this problematic. And if we have this question, we can find also answer in the EU Commission recommendations from 2022, where it's written that this directive, for example, or this activity must protect individuals and organizations against abusive criminal proceedings. So it means that in case of criminal law activities, anti-SLAPP directive can be used, but how? This is a question of the praxis. So in Germany, for example, what I have already mentioned can be mentioned as a good example where we can use anti-SLAPP directive. When we speak about Germany, we can say also that there is also some civil or private law cases, and it is also possible in defamation cases. For example, Unterlassungsanspruch, or there are two main articles in civil code in BGB of Germany, 1823 as well as 1004. This is Unterlassungsanspruch, and in these cases we can speak about the borders or restrictions of freedom of expression, also in the future, which is not regulated with the similarities in the United States of America. In this case, Of course, anti-SLAPP directive will have some binding, but in case of criminal cases, there are some questions, and according to the practical experience, we can answer, or the courts can answer this question. Next one, this is European Media Freedom Act. As I already mentioned, it is main idea to protect the journalists or journalistic content. The regulation strengthens editorial independence, and it is main idea to make some safe the freedom of speech or freedom of expression, and all of restrictions must not have or must not bribe the limit of chilling effects, which is very important, because if we speak about freedom of expression or restriction of freedom of expression, it is very important point to explain some details according to evidences or according to the cases. Similar is in the Charter of Fundamental Rights of the EU, where we have Article 7 as well as we have Article 11. And first of all, it's very important to speak about private and family life, as well as freedom of expression and information. And we have also similar direction in European Convention on Human Rights, where we have, or we can find, two main directions, Article 8, so private life, as well as yes, private and family life, as I already mentioned, and freedom of expression, of course, and defamation cases. In this field, is also very important to speak about European Court of Human Rights case law, and I will show you during the points when I will be speaking about the points about burden of proof, as well as, for example, internet cases and so on. The case how the international court defines some details of freedom of expression as well as defamation in their cases. And of course, CJEU and CJEU case law, when where we can find some details, as I already mentioned, explanations according to the Brussels 1 about the international private law and so on. So let me go to the second point, and key issues. I would like to start speaking with the question, and rhetorical question, I would say. And the rhetorical question is, what is defamation? So when we speak about defamation, we can explain lots of details, acts or regulations, or we can speak about case law from the side of international court practice, as well as experience from the local or domestic country cases. But the main point of defamation, of course, is the definition. And we, of course, cannot find a single EU definition in acts or regulations, because, as I already mentioned, EU legislation does not explicitly regulate defamation, for example, in the acts or regulations. So now, if you have a question, what is defamation, I have to ask according to the analysis, which I have already done according to the information or legislation, as well as court practice from several countries, for example, Germany, France, the UK, the US, and Georgia also. And why Georgia? If you have a question, and why, for example, not Romania or Bulgaria and so on, I can say that we have the interesting model. We have here in Georgia hybrid model, and I will explain some details when we will be speaking about burden of proof. And the main point of defamation, to make some definition, yes, direct definition of defamation, is that defamation has two main directions or two main points: false statement and moral damage. So it means that false statement must harm a person's reputation. In that case, there is possible to start the lawsuit or win the lawsuit. And in this case, does not matter is defamation or not regulated in private law, for example, in civil code or in spatial law, which can be type of private law, or is or not regulated, for example, in criminal law. In both cases, there are lots of details where the parties, for example, the plaintiff or defendants, but depends on the country's legislation, must prove some details. Was the content or not illegal? Was the fact or not false, and so on? This is the main idea, to speak about that and to explain these details. And to speak about these aspects, we have to also I have to show also some details about the criminal law defamation. Because when we speak about criminal law defamation, we don't have to think this is only from the formal side regulated. This criminal law activity in defamation field has, of course, a big history and, of course, experience. And it works, for example, in Germany, yes, what I saw. And if we speak, for example, with the German scientists, I had this opportunity to attend conference, and German professor who was criminal law professor explained some details why in Germany defamation, for example, and not only defamation, in the criminal code regulated is. Because we speak about dignity, and dignity is the most important point, for example, in Germany, as well as in other countries, yes, in democratic countries, of course, and I don't speak about countries which we know where is some problem with the legislations. And if we speak about these details and about the dignity, of course, criminal law plays a huge role. And why? In case of criminal law, the plaintiff or the person who thinks that about him was published or shared some defamatory statement can go to the police or applies police or organization with the letter, and not, for example, with the claim. In case of private law, in more states, I can say, for example, in the United States of America or in the UK and so on, the plaintiff must find, of course, the lawyer. And it means the lawyer have to receive their costs and so on. And it is not cheap because of these activities or difficulties. The idea to have the regulations or rules in criminal code about defamation was according to the explanations of dignity. But when we speak about these details, we have to explain that modern approaches promote the decriminalization of defamation. And the best example in this area is Council of Europe Parliamentary Assembly resolutions from 2007 and 2008, when is explained or written and showed that defamation must be regulated in private law. It must be one member of private law family. So it is only the idea, and in some countries, as I already mentioned, Germany, it is also regulated, but not full institution. For example, Unterlassungsanspruch, as I already said, the future restrictions of the activities and so on. But when we speak about defamation, we have to speak about two policies. First of all, this is fact. And second one, this is opinion. And why is this important, and why I should give you this information and explain this point? Because if we speak about fact, we have to speak about reality. But if we speak about opinion, in case of opinion, there is no reality. This is only position of the person who, whatever he thinks or she thinks, it must be correct. But now I have to explain these details with other explanations as well as with case studies. If we have a question, does opinion have or not limits? We can answer no. Opinion does not have any limits, but it does not mean that everybody can speak what they want. This explanation or definition of opinion can be used or explained that this is subjective nature, or opinion has a subjective nature. It cannot be proved or cannot be verified. And when we speak about burden of proof, the plaintiff or defendants, according to the legislation of the domestic or member countries, for example, EU member countries, will be or are not able to bring to the court some evidences to speak about opinion. Is this opinion correct or not? If the court decides that this freedom of activity was under opinion or content was under opinion, it means that the plaintiff will never win this case. The best example, I think, and landmark example from the international court practice is Lingens versus Austria, where was written or published the words immoral, undignified, and so on. And when the person who was the politician, so the plaintiff was the politician, started the lawsuit, he lost. He lost because the court explained that these words were only type of opinions and piece of opinions, I would say. And because it was recognized as an opinion, the plaintiff lost this case. But we cannot speak, as I already mentioned, that every freedom of or every activity of expression can be recognized as an opinion. This is here next case, Albrecht Kieser and Peter Trallau Kleinert against Germany. And here the plaintiff won the case, but of course the defendant lost. The main idea was that our speech will not be considered as an opinion, and sometimes the defendant must bring some proof or evidences that it was really not a false fact. And for example, we cannot find the golden words. What does it mean? If I say that this person, for example, is a good person, it is only my opinion and it cannot be proved. But if I speak about details, about the facts, and if I publish or share the false facts, in that case, I have proofs that these facts were according to the reality. So it is the main idea to speak, to explain these details, and every case will be decided according to these activities, according to the content, because the content plays the decided role in this area. Now, let me go to the next point, where we have to speak about scope of publishing, because these formal details or these formalities play also a crucial role in case of defamation or in defamation cases. According to the analysis of the legislation, as well as legal systems and case law, I have found or I have noticed three main points. And I can say the scope of publishing can be explained that there are three main directions. Public, and I will explain what I mean within a group, and I mean, for example, in private group, on closed group, in social media, as well as to a third person. And it means when, for example, some defamatory statement is sent to the third person directly. First of all, public. What does it mean? This is very known cases or very known cases from the whole world are made public or are published the defamatory statement public. It means that everybody is able to see this post or this activities or this statement, and everybody is able to have the access to this statement, and everybody can see what the potential defendant wrote or shared. And this content, of course, has an unlimited audience. In case of public, I will not go deeper because we can understand all these details, public post and so on. I will speak about the details, about the solution of this problem, which I have found according to this legislation and challenges which we have nowadays. Second one is the group. In case of group, there is no clearly or direct explanation of the court praxis from the court praxis. For example, is a private group or not a type of public area, or in private group if the defendant, for example, shares something in private group, does it mean or not that what he did, he had this right, and from the formal side, the plaintiff is not able to start the court cases. Last week, I received from Thomas very interesting case from Germany, from Berlin. It is from December 2025, and this case was about some statement, about some post, and the court decided that in the group, the post or statement can be deleted, but it does not mean if the court decides to delete the post, the group must be also deleted. So if the plaintiff has wants to start the lawsuit against the post, he cannot go against the group. So it is main idea to find the differences between post and group. Second one, it is from also Germany. It is a small WhatsApp group, and here is not important the content, but from the formal side is very important that in a small WhatsApp group, which we have, for example, during this project, and we have the possibility to write something in our small WhatsApp group. In those groups can be protected also the rights of the persons, and freedom of expression has also borders. And this is some main idea to speak about these details. And as well as French court decision, and there is also written about, and what was very important point to find it, why I decided to show it to you, because there is written some points about shared interest, and it does not matter is a group, closed group, private group, or public group. Here can play the crucial role, what kind of interest the members of the group have, and so on. So it depends also on the country's legislation, and according to the content or activity can be decided by the court. Now I am going to the third point, and this is the defamatory statement which can be sent to the third person. In this case, this is from European Court of Human Rights. This is Peruzzi against Italy, and the content of these activities is not important. Here is really important point to speak about these formalities, and the defamatory statement was sent to the third person directly, and it was not published or shared public. So this is also a very important point to explain these details. And if we want to find some similarities in the United States cases, I can give you a case from 2016 where also the defamatory statement was sent via email. So it can be, so defamatory lawsuit can be started because of this activity via email. So it was the American case. And now, logically, I have to go to the third point, and I have to speak about US approach in praxis, where I found some details. So when we speak about...
Sergi, there was a question of Ms. Frenzel.
Okay.
I'm reading it with respect to group. Does it make a difference whether the person concerned is a member of the group or not?
Sometimes. Does it make a difference whether the person concerned is a member? Yes, of course, this is very important point, because if a person is a member, or I don't know, is plays a big role in this group, it can also be decided or crucial point for the decision, I would say. Because of that, it is according to the activity. For example, it was really good question, and I will explain with another detail. There was a case in Georgia, but it was also about defamation case, where a party submitted or published some point in the group, and this statement was a joke, but he explained as a joke. And the court thought about this detail, and the plaintiff failed because the court explained that it was a joke. So it means that role or activity of the person, or is or not a member and so on, plays a big role. But according to the praxis, I unfortunately cannot give you the direct position according to the activities. For example, if we speak about the freedom of expression or defamation, which can be sent to the third person, yes, in this case, plays also a big role. What kind of content was this illegal or not, had this activity and so on. I hope I answered your question.
Yeah.
Okay, now I am going to the third point, and this is US approach in praxis. And why US approach? Because I would say that I have been working more than 4 years for the book about defamation, and it will be published soon, I hope. I don't know, but about in Georgian, not in English or German and so on. And I had this opportunity and also possibility to work in the United States of America and see some details about freedom of expression. And I would say that in the United States of America, there is the huge field or huge possibility to find some details and to take some details. I have taken only several details, I would say, and I will go now step by step. But first of all, I would like to show you that there are two main types or directions of defamation. It is slander and libel. In case of slander, we have the oral activity. But in case of libel, we have the written activity. In both cases, according to the American legislation as well as case law, the plaintiff must prove defamation. So must have some evidences and so on to prove the defamation. And we can speak about these details because I have also two other cases about this. But here is also very, very important point, and two details which can be taken from the United States of America. First of all, it is conditional privilege, and conditional privilege, it means the cases, according to the US praxis, when, for example, the plaintiff accepted the statement or content of statement. And there was the case when the plaintiff drank something, wine or beer or something, and confirmed that it was not problem to send this or share this statement against him. And when the person, so potential defendant, shared it, he started the lawsuit. But then they signed the statement, and because of that, we unfortunately don't have the decision. But there are about this conditional privilege lot of cases. And absolute privilege, what is also very important to speak about defamation, it is when, for example, the court decides that it was an opinion, as well as when, for example, the politicians did or shared or published some position or explained some position or defamatory activities had during the debate, for example, politician debates and so on. But if we speak about US praxis, we have to speak about New York Times against Sullivan, because it is the landmark case, not only for the American field or for this country, but for Canada, Australia, as well as the UK and other countries, because there is explained some details. This Sullivan, so the plaintiff, was a public figure, he was politician, and he won other instances, below instances, but in the Supreme Court of the United States, he lost the case against New York Times. And the main idea why he failed, it was actual malice. So it means that actual malice in case of defamation plays the crucial role, and if there is explained or there is proof that some details were according to actual malice, in that case, of course, the plaintiff can win. But, for example, the mistake is not sufficient, and the plaintiff cannot win if the defendant make some mistakes, and according to these mistakes, publish the defamatory statement. So actual malice plays a big role. And if we speak about these details, you can have a question, okay, it was a politician, but we can speak about public figures, so generally, and not only about politicians. And I can show you another case from in this case where the plaintiff was legal entity, and this is both corporation versus consumer unions of the United States. From 1984, it was after 20 years when this Sullivan case was made, and the court explained some details, and the court explained also some activities that actual malice played a huge role in this area. So if we make very small conclusion about United States of America, we can say that in the US praxis or court experience, first is speech and then is the suit. For example, if we speak about Germany, there are some details vice versa. What does it mean? That, for example, this Unterlassungsanspruch, which is also able to use in Georgia, I think, and so on. So in other European countries, we cannot have same formula. So I have to go to the fourth point, and this is burden of proof. Where I have also a rhetorical question: is this possible in the online era or not to violate the rights of the defendant, and why? If we know how to formulate our statement, how to speak something, we will never lose our case as a defendant, of course, and not as a plaintiff. Here you see the picture of Giordano Bruno, and you know where was this person and what kind of role he in history played. And if we see history of Giordano Bruno, he was not very known scientist, as for example Galileo Galilei. But we know Giordano Bruno because of his activities, because of his speeches or wording and so on, and he was banned from the society, and not only from the society, from the government and so on, because of his activity. If we take this history or example to today's reality, we can find the Facebook or I don't know, Instagram or other social media platform users as small Giordano Brunos or no new Giordano Brunos who want to share some information which can be breaking news or can be shocked somebody or somebody's, I don't know, dignity and so on. But here is very important point to speak about burden of proof and explain according to the experience, which I have already mentioned about opinion, that if a person knows what they are saying and acts responsibly, they will never fail the court. And they, for example, if I explain some details and I want to say something of wrong, or not wrong, but something bad against some person, yes, I can formulate it with the wording which can be helpful for me during this case law or during the lawsuit, and I can win this case because he will be not able to come, so the plaintiff or he will be not able to come to me and start the lawsuit against me. But when we speak about burden of proof, we have to speak about national law. For example, I have already mentioned Germany, where is it regulated in criminal code, as well as very important is France. But here's the most important point to make some conclusion about this case is the UK as well as the US, because in UK, burden of proof is on defendants, and in US, as I already mentioned, on plaintiff. And as I already said, Georgia, so my country, my homeland, where we have very, very interesting model, I would say, because in our country, we have our law about freedom of expression and defamation is made according to the US praxis, US experience, but there is also some details where it's according to the UK legislation. For example, burden of proof, but whole system or our country is member of European Union. It means family of European Unions. We have hybrid model, and it is not easy to protect the rights. But when we speak about burden of proof, here we can have one question: is it always possible to prove the true or not? And this is a question, and I would like to show you one case, so-called McDonald's case, and it is Steele and Morris against the UK. And the court explains that burden of proof cannot must not be unfairness, and it can be changed. So vice versa, the court said that burden of proof can be recognized as a vice versa instrument or institution. And if, for example, sometimes the defendant is able or must give some information or evidences about this reality or false fact and so on, and if he is not able to do it, it can go to the plaintiff. Now I am going to the fifth point, and this is private and public figures. And as I already mentioned, there are two main types of the figures, and this is public figure and private figure.
Ja, ich dachte, weil du auf Grün warst, dachte ich,
And
das läuft ja über
I have already
wird das über, also ich glaube, Rot wird nur angezeigt, irgendwie wahrscheinlich. Irgendwie so wahrscheinlich, genau. Ja, genau. Ach Mensch, die ist so schlecht heute. Ärgerlich, echt. Also, aber, ja, wirklich, ja, ich habe es jetzt leise gemacht.
Jemand spricht, ich glaube, ja.
No, I stop it.
Sorry. Ja, Entschuldigung. Okay, no problem. So I'm going back. So two main types when we speak about private figure and public persons, but here is also very important to speak about legal persons. In case of public figures, I have already shown you some details from the court practice, but here is very important point to answer this question. Is a legal person or legal entity one type of public or private figure or not? If we have this question, we can answer with the following words. No, this is not correct to speak that legal person or legal entity is one type of public or private person, but in every cases, the court must decide according to the activity of this legal entity. And if some activity of legal entity has public interest, in this case, can be used some details or some rules or some legal case law, which was already made or done for the public figures. And the best example in this case is Bladet Tromsø and Stensas versus Norway. Now I have to go to CJEU praxis, and as I call this Swedish case, and here I don't go deeper to the details, to the content, but I have to explain that in case of international defamation, in case of nowadays, when we speak about online activities on social media and so on, it is very important to explain where the center of interest is. So where the center of interest is located according to Brussels I. And there are also two other cases, so-called E-date case and Martinez case, and in both cases, or in all of these cases, CJEU decided that Brussels I have, of course, influence to the member countries and plays a big role. It means that the person can choose, so the plaintiff can choose the member country where is the center of interest and can start, of course, the defamation lawsuit. But if the decision is made, for example, in Spain, this decision can be recognized and enforced in France. And to give another example about this case, I would like to show you CJEU newest case, Real Madrid versus Le Monde. And here is the question according to Brussels I about recognition and enforcement in Spain or France, where is in which country must be recognized and enforced some cases. And of course, last but not least, we have to speak about SLAPP cases. Unfortunately, there are no big experience, not only in the international court practice, but also in the domestic court practice about anti-SLAPP cases, as well as in the United States of America. When I saw it there are some details, so-called Trump cases and so on, but this is not direct SLAPP. But we have to know that in all cases, the defendants can be journalists as well as whistleblowers, academics, and so on. And in most cases, and most often, I would say, the plaintiffs are the public person as well as the politicians. Now, we have to speak about the challenges of the internet era, and I would like to show you some practice from the international court case law as well as experience as well as from domestic law. First of all, it is Delfi against Estonia, and what is here very important point? It is not made according to ACT, but there are some similarities which can we find also. In this case, it is according to Convention of European Human Rights, but most important point is the platforms does not have any obligation to monitor some activities or find or search the illegal content, but if it is manifestly unlawful activity or illegal content, in that case, as we can see in Delphi case, the platforms might have to delete or hide the post and so on. But we can find also the case also in the European Court of Human Rights where is decide vice versa. It is MTE against Hungary, so-called Hungarian case, where was also published some activities, some statement and so on, but it was not recognized as manifestly unlawful. But what is manifestly unlawful or not manifestly unlawful? It is the question of the content or of the activity, and this is not easy to decide because according to the lawsuit must be decided these details. And now I am going to the third point, and I think this is the most terrible case what I have seen for online cases. It's Sanchez versus France, because what is the main idea? What was the main idea of this case? Sanchez was a public figure, public person, politician, and he wrote a post. The post did not have any illegal content, and somebody, two users of Facebook, wrote under this post the comments, and these comments were against legislation, against law, I would say, had illegal content. And Sanchez did not delete it and did not hide it and so on. And after then, he received penalty from the country, and he filed the lawsuit in France as well as in the European Court of Human Rights. And why is not good case, I would say, and why can be terrible effect or can have terrible effect this case? Because some governments or I don't know, politicians or some influencers and so on can decide that some activities or posts are unlawful, are against the legislation, or are illegal and so on, and they can delete it. And in that case, we can say that the users or the persons who are very known persons in a country can decide where or who can write and who cannot write some posts and activities. And one more case from CJEU practice, because it is also about platforms, about unlawful content. And here is also written very important point. It is equivalent content. And what does it mean? Here is also not defined, so we cannot find the direct definition of this equivalent content, equivalent to unlawful. And we can find, for example, this activity, or we can find the decision according to the content and activity. Now I am going to the last points of my presentation. And I want to show you a landmark case, which where I was a lawyer, so representative. A man who was more than 70 years old came to me and asked to me or gave me some to solve this problem as soon as possible. What was the main idea? He is a Georgian. He lived in Georgia, in Abkhazia, in Sukhumi, which is unfortunately occupied by Russia, and we are not able to go now there. And we had war against Russia, and it was more than 30 years ago. And this person took part in this war for Georgia against Russia. And he lost everything, friends as well as relatives there. He lost also the home, the building also, and every house and so on. And somebody wrote on Facebook as a written form that he took part for Russia against Georgia, and same person published also same information, but orally on YouTube. And in both cases, everybody had access to this post or to these activities, and this person, my client, had this heart attack, and he spent whole night in the hospital. Then he came to me and gave me this tool to start this thinking about the solution of this problem. And it is not easy, because when we speak about lengthy nature of the processing, sometimes it is more than 2 years or 1 year and so on. And in case of online activities, it is really, really long time. And because of that, I decided, I had an article, and according to this article, I decided to use this in the practice. And I asked the court about provisional measure. And this case was used also in the United States of America from my colleague. I have explained him these details and what was the main idea. Landmark case, and why? Because this is a landmark case not only for Georgia, but for the whole world. I have not found similar case in other countries, also in the case law of international courts. I asked the court about provisional measure, and according to our provisional civil procedure law code, the court has 24 hours to make decision but about provisional measure and not about, of course, the claim. And I asked the court to switch the public post to only me, and to do it until enforcement. And the court accepted it, and it means it was enforced, what is also a very important point. My colleague in the United States of America used to do it, but the court did not accept because his client was a politician. My client was not a politician, and it played positive role. I want to show you another point from the practice which I have already tried. It is editing of the post and placement of emojis. It means I went also to court with the claim and with the provisional measure, and I asked the court to make this decision to accept my position. It was about the editing. So the defendant had to edit the post, and next to the wording or next to defamatory statement, he had to write that a defamation dispute is ongoing concerning the content of this post, and he had to show also these emojis with red color. And idea was because I wanted to keep everything untouchable. For example, post, and I did not want it to switch it from public to only me, but I wanted to make some editing of this post. But unfortunately, the court did not accept my position. But in this position, my client was a public person. And in case of American practice, because my colleague in New York State, used also same case, and he went to court, but the court also did not accept. In this case, also his client was public figure, public person, but the court explained according to this practice and of course actual malice, as well as about this point that it is against freedom of expression. So the last point, I would say, it is the 7th point of our presentation. AI and defamation is of course the new point. As Thomas already mentioned, I have worked. Also, I had this opportunity to work in Münster during the last summer and prepared some details, some cases. But unfortunately, there are not lots of cases in the whole world about AI and defamation. But because we have from the United States of America, we have to show this case, or I have to show this case. To view OpenAI, so I mean ChatGPT, generated some information about Walters, so potential plaintiff, and did it not correctly. It was false fact. And this communication with ChatGPT, so OpenAI, had one journalist. And then this journalist went to Walters and asked about these details, about the situation and so on. And when Walters received this information, of course, he answered and said that it was not according to the reality, it was false fact or false activity. And he went court and he submitted claim against OpenAI because of this activity, because OpenAI generated something wrong. But he failed. And the main idea why he failed was actual Malice, of course, this American practice. But we can, according to this decision, we can find some details whereabout we can speak and make some, analyze these activities. It is my opinion in this case, it is not direct written in this decision, but very important to see the idea or some direction which the court in this case made. So person who use AI must check the information before the publishing. And in all cases, it is also my position, this is a problem, or this is liability of the person who publish or shares this information. And if we speak about statistical AI has black box, it means hallucinations. And in this case, AI cannot give 100% warranty about information, and that this information is according to the reality and so on. And because of that, the prompt cannot be recognized as an evidence in these cases. And what I have already mentioned, I would say similar case is now ongoing in the Republic of Ireland, Defamation versus Microsoft and BNN. And his really, really important point and very crucial point, I would say, is that BNN published the information again about their finding, and BNN did not mention that everything was according to these activities with AI. But after their training started some activities, then BNN explained that it was from Microsoft AI. They did everything after this prompt and so on. And now we will see, because the decision is not made. And let's see what kind of decision the court in this case make, or how decides. And the last point in this area, it is, as I promised, an Australian case, because I found this case in Australia. I have not been to Australia, but I found it that it was pre-litigation process. It means the plaintiff, the mayor, did not go to the court, did not start lawsuit. But what was very important point, after the communication with ChatGPT, he received information, or ChatGPT shared information or generated information against this person, and wrote something wrong. It was false fact, or it was against the reality, against the truth. And then this mayor went to OpenAI, or asked OpenAI, and asked the correction of information, which OpenAI did. And because OpenAI corrected this information, mayor did not go to the court, and we have lost, I would say, very interesting case. But let's see in the future, it can be also started in other cases. So last point is conclusion. I will try to explain some details in a nutshell, that EU regulation does not have any direct act or regulation, or EU does not have any and don't have any direct regulations or acts about defamation. There is no direct definition of defamation, but if we speak about the definition, or if we speak about explanation, and if we want to explain defamation activities, we have to speak about false fact as well as damage, as well as moral damage and some activity which can harm the person's reputation or reputation of legal entity. And there is also a very important point that a burden of proof is not only the formal institutions and can play the significant role in nowadays in those cases. And so defamation cases can be developed according to the developing of AI as well as social media, internet, and so on. So thank you very much for your attention, and I think we can start the discussion.
Wow. Great. You've done a wonderful job. Highly intelligent, perfect in time. I cannot give you as a gift, as the tradition in Münster is, a bottle of Georgian red wine. It means Eulen nach Athen tragen. But I will bring a special gift for you when I come to Tbilisi.
Thank you very much.
So the floor is up for you questions. Let me only ask one question, which strikes me. In Europe, we are thinking of having a specific regulations on hate speech.
Yes.
How do you see defamation law in relation to hate speech? Is hate speech a new category or the same as a lower defamation law approach? What is it?
It is really good question, but I did not want to go with hate speech activities or directions. And why? For example, when we speak about DSA as well as ECD and so on, we can explain that this unlawful activity can be recognized according to the hate speech. So hate speech, it is regulated from the European side, of course, but it has another direction and not similar direction whereabout I have already explained or mentioned in case of defamation. So if we speak about hate speech, of course, hate speech does not have the big freedom, I would say, and has, of course, the borders, but it is not similar, it's not regulated in similar ways what we can find in defamation. And for example, when I ask the also German companies, that not only German companies, but also French companies, they had the answer about this question that defamation with hate speech and without hate speech. Because if we speak at hate speech, it is the easiest way, I would say, to go to court and start the lawsuit, because hate speech is regulated and there are more regulations about that.
So, further questions? I don't see any questions. I see Ms. Riegel-Traut is carefully looking to the ground.
I do have a question.
No. Okay. Don't be embarrassed. I don't want to embarrass you.
Oh, no problem at all. I wondered the concept. I think I'm not sure whether I fully grasped it, but I'm looking for the slide. That's why I.
That's one point.
The Social Media Council. That's the question. What I have, because I wondered what that actually is. Because in Germany, I understood that you said it is new because lawsuits take a long time, and to get your right faster, that's a concept within a platform, a position within maybe Google or something like that. But I wondered, we have interim legal protection. So that's how we can get faster our right. That's why I wondered, don't you have that in Georgia to get interim legal protection?
This is a good question. Thank you very much. When we speak about social media council or alternative possibility to solve these problems in all internet era, ADR in defamation cases and in case of freedom of expression, we have to speak from the globalization, I would say, because I had some possibility to speak with American scientists, and they told me that if you have a question or some, I don't know, claim and so on, you can come to us, to the social media councils of platforms and start the lawsuit. But it does not work. And this is the problem. It does not work because in every case, for example, in Germany, there are some similar ways, but not social media council directly. It means that there are node chambers from the civil society as well as from scientists and so on. And in Germany, for example, there is no institution who can make the decision so directly or as soon as possible, which can be enforced. I don't speak about DSA. I speak direct about social media council, and it can be similar with which we have, for example, in business cases, arbitration. Yes, and in the United States of America, they had a big problem. When I sent some details, because I sent this as an example, as a draft of claim, because something in my case, which I have already mentioned about this only me and so on, was written or published some defamatory statement. And they did not understand anything because they wanted to decide according to the American law. And social media council, the main idea is to make everything according to the local legislation and not from global legislation. So it means if, for example, in Germany, something is defamatory and something not, and the European Human Rights Court has already decided in case of freedom of expression under this religion activities, Turkey case, and it was also this French case, Giniewski against France and IA against Turkey. In both cases, they said, okay, in this case, in French, it cannot violate some rights of person, but in Turkey, yes, because there are difficult activities, difficult moral ideas, and so on and so on. Because of that, when we speak about globalization, this is a main problem in online there. And of course, what is also second problem? For example, when we speak about Germany, I had also a German client in Georgia, and there were two people, and they had shares in the company, and they had some lawsuit against each other. And one person wrote on Facebook against other person. Both of them were Germans in Georgia, something defamatory. And we started lawsuit in Georgia against this person, and both of them were German. But we asked the court about damage. About damage, it was approximately 50,000 euro. And we saw that we can have some problems in the future if we win this case or won the case, because recognition and enforcement of defamation case in Germany cannot be easy, or I don't know, it cannot be used. And social media platform can solve this problem because we will have possibility to go direct to this council and to ask this council, and this council, for example, not in case of damage, but in case of other activities, can, of course, delete some post or hide some post and so on. As well as second point, what is also a very important point from my case. I had also a client who was businessman and somebody, and as we thought, but we don't know now, it was the employee of this person wrote something on Facebook, and they used this Facebook, and this person was from China, but does not matter was from China or not. He did it in Georgia, according to the Georgian activities and so on, because he had also this employment agreement. And what was very important, this activity was under the anonymous account. And we went to court and asked the court to start some activities and to make some order to know who is under this account. The court accepted our position, decided and published the ruling, but our Ministry of Internal Affairs had not a possibility to do it. And when we went to the United States of America, we sent this letter to the United States of America to YouTube. YouTube said us or told us that okay, it was not case according to the US legislation. It means the direct possibility of enforcement we unfortunately don't have. I don't speak not only about Georgia, but I can speak also about Australia because I had this possibility to speak with them. Australia, New Zealand, because there is also code. For example, in New Zealand, there is code, so-called code. It means that the government recognize the code as a regulation for these activities on social media or online platforms.
So very good answer because it was just in time. We stop at 45. We see each other next week at the same time here, 10 to 12. We have a Q&A. I will explain to you the final exam. You get the real final sheets of Sergi after that speech, so you get a nice collection of actual PowerPoint sheets. Thank you for listening. Have a good week. See you all in good shape next week, Tuesday, 10:15 to 12.
Thank you very
Thank you.
much.
Thank you so
Bye.
much.
Goodbye.
Goodbye.
Thank you.